Hey there guys, if you get a chance to do free movement of workers on an exam or a piece of coursework, then definitely give it a go. There's loads of cases to use irregardless of the situation, loads of stuff you can apply, and I think it's a fairly straightforward topic. So let's have a look at it now. I know that we seem to do this on every topic, but it's always best to start with a definition. So in the same way that when we did free movement of goods, we defined what goods were, we need to here define what workers are. So there's one key case that we can use for this. This is the Laurie Blum case from 1986. And basically the court in this case decided that a worker was someone who during a period of time performs services under the direction of another in return for remuneration. So we'll explore this in a little bit more detail now. In particular, I think we can split this up into two areas. So the economic aspects of a worker and the formal aspects of a worker. So in the Stamen case, we found that the remuneration or the payment doesn't actually have to be money. So if you work in a job and you get paid with food and board, for example, then that's enough to still count you as a worker in the eyes of EU law. And also in Kempf, they decided that the payment, if it is in money, doesn't actually have to be enough to live on. So in that case, the worker still relied on benefits from the state in order to be able to live in the country. And they said that that was still okay. They were still classed as a worker, despite not earning very much. So some of the formal aspects, very quickly, Levine said that it doesn't have to be full-time work, it can be part-time work as well. And then Hoekstra as well from 1964 said that even where someone loses their job, they should be given a reasonable amount of time if they're looking for another job. So obviously the main article that we're going to be looking at for free movement of workers is Article 45.1. And I think that the format of Article 45 itself lends its way to a good way of approaching the revision. So Article 45.1, first of all, basically just sets out the right that free movement of workers should be secured in the EU. Sounds very obvious, but I think it's something that people quite often miss when they're writing exam answers. They're often looking for, in a problem question, of ways of getting the people out of the country. But I think that if you remember that this is the European Union, so we're trying to bring people together, then free movement of workers is all about making sure that there is that union in place from one country to another. 45.2, do not discriminate against foreign workers. So in Collins, which is a fairly recent case from 2004, Collins was denied access to job seekers allowance, and they said that while under free movement of workers you should be entitled to exactly the same benefits, whether that be tax, social security or otherwise, as if you were a British national or a national of the member state where you were in. So 45.3 is quite sizable, so we're going to spend a little bit of time on it, but it basically looks at the rights and limitations. So 45.3 itself is split up into 4 separate subparts, and these are all listed within the article itself. And they're very basic rights that are set out. We'll look at developing them a little bit more in a second, but for the time being, you can accept offers of employment, move freely within the member state, so north to south, east to west. Right to remain in the member state for a job, so if you do get a job, then you can stay in the member state and work there. And right to remain after having been employed, and we'll look at what that actually means in a little bit. And let's go into sort of some of the case law, and in particular the most important directive that you'll need to be aware of when doing free movement of workers is Directive 2004/38, as this expands on some of the rights of workers. There's the right to enter and leave, which is important. The right to reside is set out in Article 6 of Directive 2004/38. In particular, Article 6 says that once you arrive in the country, even if you don't have a job, you have the right to reside there for 3 months. Now, after 3 months, things get a little bit more complicated, because you would have to show that it looks likely that you're going to get a job. If after 3 months it seems that you haven't got a chance of finding a job, then the member state will be able to kick you out. But if you can show that you are sort of looking at being realistically in a position of being able to get a job, say for example you've got an interview for a job the following week, then it's unlikely the member state will be able to kick you out. So this has developed through a number of cases. I think the most famous example is Antoniessen from 1991. In this case, the person had been in the UK, I think it was for 6 months, and the EU court basically said, well, that's more than enough time to find a job, and if you haven't found one by that point, then the UK was right to kick Antoniessen out of the country. Couple more rights here as well. Right to remain after losing a job. So we talked about this a little bit earlier, but it could be because of illness, involuntary unemployment. So if you get made redundant, for example, or if you're entering vocational training as well. So if you're training in a particular trade, then you can also remain if you've lost your job. Right to permanent residence after 5 years. So if you do come to the country, you find a job within 3 months, you really like it, you settle down, then after 5 years you can gain the right to permanent residence, and at that point you're basically treated as if you were a national of that member state. So if you went to France, you found a job there, worked in France for 5 years, then after 5 years you would essentially be treated in the same way as a French citizen would. So as well as having various rights for workers under Article 45.3, it also sets out that there are limitations as well. So public policy, Van Duyn is the most famous case from this from 1974. Van Duyn was a Dutch Scientologist who tried to come to the UK, and the UK didn't want Van Duyn in the country because they thought Scientologists are a little bit weird and we don't really want them here. And in this case, the European Court agreed and said that the member state gets to choose on the basis of their culture what is in the interests of public policy and what isn't. So if the UK feels that Scientology is a bit of a weird cult, then they can block Scientologists from coming into the country. Now, obviously, that's a little bit harsh and very much a judgment of its time, and so we can bring it a little bit more up to date with Article 27.2 of the directive. And this article basically says that the person would have to be a direct and immediate threat to the country. So obviously in Van Duyn, even though the UK might think Scientology is a little bit weird, because it isn't a direct and present threat, they would no longer since 2004 be allowed to kick Van Duyn out of the country. So there's been a move away from a liberal approach to public policy. Public security as well, Crown against Bouchereau. This is a criminal case where a worker came to the UK from France, had committed a crime, and the UK tried to send Bouchereau back to France on the basis that they were a threat to public security. And the court in this case identified 2 key factors when looking at a worker's previous criminal conviction. Not only do you have to look at the seriousness of the crime, so obviously something like murder would be very serious, whereas petty theft would be a lot less serious. You also have to look at, if there are previous convictions, how long ago they were. So if someone had been convicted for petty theft 15-20 years ago, obviously that's not very serious and not really a threat to public security. Whereas if someone had only recently been released from prison for murder, then you would probably have to say that there is a good reason there for not letting them into the country on security grounds. Finally, the other limitation that we can have is public health. This includes contagious and epidemic diseases. Relatively obvious, really. Obviously, if something like Ebola or bird flu was sort of more of a threat than it was, then you don't want that spreading right across the whole of the EU. And so there are limitations that can be put in place for those types of diseases. Probably important to note as well that HIV and AIDS is not included as a contagious or epidemic disease. So there's no discrimination against people who have HIV or AIDS. Article 45.4 is public sector, which are excluded from the free movement of persons. This might seem a little bit harsh at first because you're thinking, well, if all of the jobs are open to people, then why are public sector jobs excluded? But if you think about it, a lot of jobs in the public sector, such as being a policeman or being in the army, being a civil servant, are often very closely related to national security. And so it's maybe not always wise to have people from other countries fulfilling those roles. So that's something to watch out for in exam questions. And that's about it. Bit of a shorter video there, but you'll notice that we actually covered probably a wider range of cases and rights and limitations within that short period than we did on other topics, such as free movement of goods. So that's why I think that it's a real advantage picking this topic for an exam. You can cover a wide range of issues, they're applicable in pretty much all scenarios, and it's just a case of you picking out the relevant rights and limitations to apply to any particular situation. I hope you found it useful. Remember to leave a like, comment if you've got any questions or requests for other videos. I saw some people want competition law, so I might try and do something on that. And also make sure you subscribe for more videos. Thanks very much for watching. Bye.